Don't worry about timekeeping and so. Okay. I'm just going to ask that we start by just 30 seconds. Whatever your religion is, whatever your beliefs are, 30 seconds of silence to remember those that has lost it completely, those that died, especially the children. Just 30 seconds, please. Thank you, everybody. Many of you know me or know about me, and so let me introduce myself just briefly. I believe that I was put in this position by a much more powerful entity. Many years ago, I took notice of many families that come and say, this is happening to me, that is happening to me, and so, and you look at the person and say, he must be crazy. That woman, I think her head, there must be something wrong with her. This cannot happen in modern society. And I ignored many people that asked me just to comfort them. I just ignored it. And then God decided to put me through it. And that's how I did get involved. The date is 22 February 2008. Okay, it's several years later, I'm still going. I had to learn from scratch how to handle it. I managed to get quite a bit done. The last little bit that I have done is in 2009 I started, and this is now the background, I realized that I, my wife, my children are victims of several offenses. And I tried to highlight these offenses to Angara Shakona. And I was just pushed away. I then ended up in the district court as a common informer to try and prosecute it myself. Naturally, the state, in that case the HSE, as well as the state solicitors, they had a big fight against me. And in the district court, after about 7-8 months, the judge just adjourning it every time, the judge just decided he is refusing my application to be heard as a common informer. I appealed it to the circuit court. Circuit court decided this is not for an appeal, this is for a judicial review. I went in for judicial review. Again, naturally, same barristers and solicitors stood up against me in front of the judge, and the judge refused my application. So I lost out again. But the judge did something very interesting. He gave me a tip on the sideline during his judgment. I used that tip and I launched a second judicial review. The second judicial review I also lost. I appealed it to the Supreme Court. I had to wait several years to get a Supreme Court date. And the Supreme Court was quite interested in what I had to say. After a second and a third hearing, the third hearing was on the 16th of January 2016. The Supreme Court ruled that my appeal is granted and matter must go back to the High Court, but the Supreme Court ruled that I had the wrong respondent. I had, at that stage, the Minister of Justice as a respondent. The Supreme Court ruled it must be the GARA Commissioner respondent and the DPP must be notice party. Now, new respondents, but same legal team, because they are all represented by the state solicitors in Dublin. The same legal team kept on fighting against me. 16, 17, 18, 19. Now, in 2019, in July, there was a case in the European Court of Human Rights against Russia. You'll see it on one of the documents there that I mention it. And that case was judged, and it was virtually similar to my case. And it was in favor of the plaintiff against Russia. Russia is in breach of the European Convention of Human Rights by allowing the offences not to be investigated. Now that filtered through to the state solicitors, and on the 23rd of July 2019, they agreed to give up the fight, and the court ruled in my favour. Well, I say my favour because I was the plaintiff at that stage, but the court ruled in everybody's favour. The court ruled that offences committed during in-camera proceedings can be investigated and prosecuted as by law. Now, before that, the moment you say family law, childcare law, immediately they say, in camera, we can do nothing. Now, it has changed. The court decided it have to be investigated and prosecuted as by law. So that is basically the background of the whole story. I'm going to go now and I'm going to ask us to look at a piece of paper for those who are printed, Parental Alienation, Possible Offences. Now you won't know, but in 99% of the cases where there is parental alienation, there is offences committed. Now I'm going to try and go very fast through it. It's a big book. It's 23 pages. Not all of it I'm going to discuss. I'm just going to give the basic background, and then we're going to start having a little bit of a workshop and examples. Now, if you go to that link that you will get, you'll see the case number and an extract of the court order. The court does grant a declaration that a prosecution for a criminal offence allegedly occurring during the course of civil proceedings heard in a court of law otherwise than in public, in camera, is capable of being investigated and prosecuted as prescribed by law. Now suddenly, the immunity that the offender had has now disappeared. We don't know, there is several of you here where offences occurred many years ago. If you walked into, the Supreme Court ruled that if you walked into the guard station and you tried to report it, that offence, the time clock or statute of limitation stopped running. Just for those who don't know what statute of limitations is. Some offences have a statute of limitation. That means if I commit the offence today, in 6 months' time, you can't prosecute me anymore. But if one day before the 6 months you report it, then I can still be prosecuted. Now, that is a statute of limitation. That stopped running the moment you try to report it and the guard say, sorry, it's in camera. I'm not willing to listen to you. So, most of you, or all of you, went to the guard station and you tried to report the wrongs. We're going to come back to that later. Now, it is very interesting to see the different offences that is involved. But before that, I must highlight the fact that parental alienation, any form of parental alienation, is an offence of cruelty to children, and it is child abuse. And that is what nobody wants to understand, and we have to educate them. And I'm going to ask all of you to put feelers out to try and find so-called super duper pooper scoopers, court officials and so, to understand this and start highlighting it. In most of these cases, if I try to alienate you from your child, what is the main purpose? What's the main purpose?
Control.
You want to control. You want control of the child, but am I allowed to have any control of the child? Or is he allowed to have any control if I alienate? No, he's not allowed any control. He's not allowed to have any relationship. Number one, he is going to get tired. Many of the dads or moms, or as we call them, the target parent, many of them give up hope completely. And they just say, okay, goodbye, I'm going. So what did they do? They actually committed an offense by abandoning the child. Child abandonment. But I coerced him into abandoning his child. So basically, it's not going to be fair to prosecute him. But, and you will understand it later, if I coerce him into abandoning his child, then number one, I'm guilty of an offense of coercion. You'll see later. Number two, I am procuring the abandonment of the child. Procuring abandonment of a child is an offense. The solicitor that assists me to get the court order is assisting. So the solicitor is also technically guilty of an offense of procuring abandonment or assisting in the abandonment of the child. His solicitor that just wanted to keep the matter in court so that he must pay, is also guilty of the same offense. And by the way, my solicitor also get paid by me. his solicitor get paid, they both make money. Now we're coming to another offence that might be involved here, and that is corruption. That still corruption is also involved. So now we talked about abandoning a child, but the cruelty that I inflicted on the child by pathogenically parenting the child to abandon the target parent. The changes I cause in the brains of that child, they call it neuroplasticity. That is cruelty to children. We're going to come back to that. Let's just summarize the offences quickly for you, and where needed we can look deeper into it. The first one, and you won't believe it, is the Marriage Act of 1542. Yes, it is still valid. The Marriage Act of 1542 is still valid, and it is now the shortest act on the Irish Statute book, because it has been, a lot of things has been taken out. The whole act read, and that no reservation or prohibition, God's law except, shall trouble or impeach any marriage without the Levitical degrees. Now, that is powerful. That means, if I go and get a girlfriend and cheat on my wife, then I am troubling my marriage. If you run and you have a relationship with my wife behind my back, you are troubling my marriage. So you're guilty of an offense. Now, unfortunately, in the act of those days, the sentence was not mentioned in the act itself. So I did some research, and this is now interesting. The courts did find people guilty. Adultery, other things, many other reasons, the courts did find people guilty of that offense. And the sentences that was issued ranged from 1 day in the pillory, your head and your arms. It ended. There was also physical chastisement, but in some cases, it was a prison sentence at the will of the Crown. That means you go to jail, and everybody forget about you, except if one of your friends can ask the King or the Governor General in Ireland to pardon you. And some people died in jail because of that offense. That is the first interesting one. And if there's anybody here with legal contacts, try and see what your legal contacts say about that one.